In this final lesson examining the three certainties for the law of trusts, we're going to move away from our understanding of the fixed trust, which was what last lesson was exploring, and start to talk about the concept of the discretionary trust and how the three certainties are applied in that regard, specifically the certainty of objects, owing to the nature of the beneficiaries that are cited in a discretionary trust system. So, ultimately, if we turn back to previous lessons, we noted that essentially what a discretionary trust is a trust instrument. So we have a settler that is transferring property to a trustee for the benefit of some beneficiary or some class of beneficiaries. But there is a certain amount of, as the name suggests, discretion that is given to the trustee when it comes to the distribution of the property shares to the class of beneficiaries. That's where the concept of a discretionary trust comes from. This is compared to, for example, the idea of the fixed trust, where with a fixed trust you have a clear class of beneficiaries or a clear beneficiary, and there is no room for the trustee to distribute that property in any way they see fit, but in a way that is prescribed by the trust instrument specifically. In a number of cases, the idea of a discretionary trust often denotes something where there is a large collection of beneficiaries. So there's not an expectation in those cases that the shares will be distributed equally. And this is really where we get to the different kinds of distribution when it comes to different kinds of discretionary trusts. And one such example is the case of McPhail and Dalton from 1971. In this case, you have the settler who establishes a trust fund, which would be for the benefit of his employees. Um, Ultimately, this was a discretionary trust, and as a result of which, the property being held on trust by the trustees were instructed to distribute the property, quote, as they saw fit. So there is a certain amount of discretion that is given to the trustee in terms of distributing the property. Very, very simple. And what is important in this regard, therefore, is that when you have a situation like this, there is a certain amount of power that is granted to a trustee in doing so, in being able to distribute said property. But comparing this to a power versus a trust, you have to obviously make it very clear that with a power there is the ability to default on this authority, but with a discretionary trust there is not that same ability to do so. A discretionary trust requires there be an obligation for the trustee to actually distribute the property. There is an obligation to do that, but the where the discretion comes in is how that property is distributed. Now, the question of whether or not a trust existed was the question of whether or not it could exist without there being a complete list of names. So if you think back to the previous lesson, there was this idea of to satisfy the certainty of objects, you need to have conceptual certainty. And one of the ways in which you have conceptual certainty is to have a complete list of beneficiaries. And it was held in this case that a trust did exist, but did exist without the need for there to be this complete list, as distinct from the test which requires a complete list. In this case, it was held that a trustee with a duty to distribute, particularly among a potentially very large class of beneficiaries, so for example, a very large number of employees, would surely never require the preparation of a complete list of names, which anyhow would tell him little that he needs to know. So essentially, it was held that the idea of a complete list would be a moot point in relation to the distribution of property in this particular trust instrument. Compare this to the Rebaden case from 1973, so slightly afterwards. Again, this is a follow-up case from the previous slide, and the question in this case was whether or not the inclusion of the, quote, relatives of the employees was sufficiently certain to qualify the certainty of objects and therefore qualify the creation of an express trust. It was held that upon application of a class approach compared to a complete list approach, we actually get three different answers. According to Lord Justice Stamp, a strict and literal application of the class test ought to be applied. And what this means is that the approach is satisfied when you can say of any individual whether or not they are a member of the class. So this is a strict and literal approach application of the class test, and it simply requires you to be able to pick out an individual and be able to say whether or not that individual is a member of the class. And if you can then satisfy that, then you may be able to satisfy the sufficient certainty that is required for the certainty of objects. A more moderate approach was taken by Lord Justice Sachs, who argued that the claimant should be able to prove they are within the class. So rather than looking at an individual and saying that they are making a strict and literal interpretation as to whether or not they are in the class at the time, Lord Sachs says that it could be the case that the claimant should be able to prove that they are within the class. There should be a certain amount of leeway and discretion given to a claimant in order for them to be able to prove that they are part of the class, and therefore satisfy the sufficiently certain for the certainty of objects, and B, actually get a benefit under the trust. And then Lord Justice Magar suggested that the application of the, quote, substantial numbers test ought to be applied in this case. And what the substantial numbers test suggests is that the is or is not within the meaning of the trust does not imply that any person is or is not a member of the trust itself. This is a relatively interesting case, and it does essentially spit out three different approaches to looking at the idea of sufficient certainty for the purposes of a discretionary trust, and we will do some more lessons on this in the future, looking at even more cases in and around this area.